This is Indie Originals Live, the official host and sponsor of IndieCon, and the official Indie Originals music, literature, and film competition. Heard every Friday at 9 on 16 radio stations all across the United States and globally on podcast everywhere. Featuring your hosts, Chuck Fresh and Felicia B. Marcella Dominguez graduated with her JD in 2011 from the Western Michigan University Cooley Law School in Grand Rapids, Michigan. She returned to her native hometown of El Paso and started as a trademark attorney there, but soon expanded her geographical area of practice nationwide. Her strong interest in trademark law and copyright law is driven by her belief that protecting creativity is crucial to lasting success. Her personal creative pursuits, including managing StoeyJoey.com, a cool little company inspired by her own kids, gives her a unique perspective that other creative legal counsel may lack. To connect with Marcella Dominguez and defend your creative endeavors and rights, including forming a business entity such as an LLC or registering your trademark and copyright registrations and much more, hit up www.marcellatm.com or find her on social media at Arts Music Lawyer. She promises to defend your business as she would her own. Welcome, Marcella Dominguez. Is that how you say your name?
Yes.
Marcella Dominguez. That sounds like a rhyme, like poetry. It just flows together. Did your parents pick that name on purpose?
I think she just picked Marcella randomly. I don't know. Maybe it's because there aren't a lot of people in our community named Marcella. That's my best guess.
Marcella Dominguez. I like it. It goes. So I see you're an artist. It says from your website that you're a member of the American Institute of Graphic Arts. You do art?
Well, I don't do art, but the reason that I joined was because I feel like I identify with artists in the sense that they're all right brain people.
Right.
They tend to use their creative senses a little bit more than, say, technical industries or technical careers like lawyers, doctors, people that are very methodical. And so I've always tried to use the right side of my brain when I can. And every time I see a business that a right brain person runs, it's like, oh, it's so fascinating to me.
You understand that disconnect between left brain, right brain, the creative people versus business people.
Yeah. And so I think AIGA was just the right place for me in terms of identifying with those people, though I am a lawyer.
Ah, gotcha. Well, lawyer is kind of an artistic profession. You have to come up with creative solutions to certain things, right?
Yes, we do. Yes, we do. I would say that that's probably, the creative solution, for example, in criminal law would probably be a little bit different than a creative solution, say, in trademark law. But yes, nonetheless, they have that creativity factor in common.
Very cool. Very cool. So let's begin with defining IP, which is intellectual property. How would you define it as a official lawyer person?
The technical definition, there is a technical definition for each one of them, right? Because IP encompasses copyrights, trademarks, and patents.
Okay.
So I don't practice patent law,
okay.
Which if you are looking for a patent lawyer, it would be good if you found somebody who specializes in that field, because there is an extra test that a patent lawyer has to take. So there are patent lawyers, and then I do mostly trademarks with a little bit of copyright law. And trademark law, to me, if I had to describe it in its most basic form, it helps creative people basically protect their brands, which means either their business name, their slogan, their tagline, or their logo. And then copyrights is kind of, everything that's in every type of expression that you can actually formulate and manifest into something, whether that's song lyrics, whether it's a painting, whether it's poetry, a book, a creative form of expression that manifests itself in some way. That is copyrights. It's protectable by copyrights.
Right. Okay. So that's different. The trademarks, like protecting, would you use a trademark for protecting the name of a band, maybe, for a musician?
Yes, that's right. You would use a trademark to protect the name of a band. Yeah.
Gotcha. Okay. So a lot of people are like, well, I should copyright the name of my band, but that's not actually technically correct. You can't really copyright the name of a band. You would trademark it, right?
That's right. Yeah. And I know that there's a lot of confusion just because it's not everyone's area of expertise, which is totally fine. But that's why you listen to podcasts like these, so that you can refine your education as it relates to the things that you're doing. Whether that's, forming a band, writing lyrics. So if you write lyrics, you would copyright them. But if you're forming a band and you want to protect the name of your band, yes, you would trademark it.
Gotcha. Now, is there a different process for trademarking? Like if you have a logo for the band or just the name, or do they both get trademarked together?
That's a good question. And so when you file a trademark application, whether you're filing a logo or a name, the process is going to be the same, except for except for one of the steps within the application process. You see, when you fill out a trademark application, the USPTO basically forces you to identify this application as protecting the name or protecting the logo. Yes. And so you cannot elect to protect both of those within an application. But as I was actually explaining to someone earlier today, the closest you can get to protecting both of those in a single application is, I'll give you the example of McDonald's. Everyone recognizes the golden arches, and everyone knows that the name McDonald's is it's slapped across the golden arches.
Right.
So that would actually be protected as a stylized mark, which is a logo application. But within the logo application, you have words. And those words in this example are McDonald's. And so even though you are choosing to protect it as a logo, if someone else, let's say, decided to register the trademark for the name McDonald's, more than likely, they would actually receive an office action that says there's a logo application out there that uses the word McDonald's. So to be honest with you, it's a little bit confusing and a little bit convoluted the way it works, because it's almost like there's no rhyme or reason or logic. Why are you being stopped from using their name if this is a logo application, not a word mark application? But that's just the way it works.
Yeah.
So, but I before I let you move on to the next question, I do want to say that if you are very serious about your band, if you're very serious about the future of your business, then the best thing to do is actually to file an application for both. Some of the biggest companies like Puma, Mercedes, just anything that you can think of, has a variety of applications. So, I mean, sometimes these applications number in the hundreds, because they'll register the varieties of logos, the varieties of word marks, or whatever it is that they have. And so that is the way to achieve the most comprehensive protection for your brand. But if you're just starting out, you can choose either word mark or logo or whatever you want to protect.
Well, I'm going to tell you my personal experience, and that's how you came to my attention. I filed for a trademark, and the application online seems simple enough. You go through, it's pretty self-explanatory until they hit you back with that notice, and they come up with all these kind of strange alien languages that I don't understand, which I'm going to need your help with. So we'll talk about that after this interview. But they come up with a bunch of things telling us about classes. You can't file this class, or it's not applicable, or it's too generic, so you can't trademark this particular aspect of your name. But it's you really can't do it yourself unless it's clear cut. And I don't even think if it's clear cut that a layman could do this themselves. There's so many pitfalls involved.
Yeah, I get feedback from both ends of the spectrum. One, gosh, I should never have done this myself. And I have that post actually because someone texted that to me. I should have never, ever done this myself. And so I said, this is exactly what I need to post on social media for people to see and realize.
I'll write one because you can have mine too. Yeah.
Yeah. And then I get other people that, I see on forums that say, I did it myself. It's a really simple process. If you have somewhat of a brain, you'd be able to figure it out yourself. And, I always say, you could have been lucky. And that's just it. You had one application, you had luck one time. But now if you try and start filing your second and your third and your fourth, and all you understand is, the basics. I'm not so sure that luck would strike a second, third, and fourth time.
Right. And it really depends who your examiner is too. If they're cranky that day, and you're stuck with that person through the whole process, aren't you?
Yeah, that's right. And fortunately, of the number of applications that I've come across my desk, I've only run across one trademark examiner who was very, just.
I think I have him.
Agreeable.
Yeah, I think I have him. I'm not going to mention any names. I'll tell you off the record, but man, this guy's beating me up big time. So we'll have to talk, definitely. I hope it's not the same guy.
I hope so too. I hope not too. But one or two can be difficult. Most of the time, if you can get someone that's going to communicate well with you, responds to your emails or returns your phone calls, and you're on a path of efficient communication,
right?
I think that you'll hopefully end up in a place that you were meant to be, which is with a registered trademark.
Not me. I give up. I'm talking. It's in your hands now. I'm done. So let's talk about I know we have limited time here, so I'm going to kind of power through these things. And I definitely like to talk to you again. There's so many questions that band members have asked me. Not that I know anything, but they consider me to be an authority, which is incorrect. Mm-hmm. You're the authority here. If a band files a copyright, what does that really protect? Does it protect the lyrics and the music? Or are there different forms you can file to protect the recorded song versus the lyrics? Or do you need to file both?
So that's a good question too. You can, I'll be honest, I actually don't file them as often, but I have filed them in the past. So my memory tends to lapse a little bit when it comes to exactly what to file, unless I'm looking at the application directly. But you can, there's a copyright in the sound recording, and then there's a copyright in the lyrics. And so those are two different copyrights, and there's an exponential amount of people that can own the copyright when you start talking about registering a copyright for sound recordings, registering the copyright in the lyrics based on the number of people that have contributed to that work.
Okay.
So let's say, 3 people contribute to the lyrics. Then each of those 3 people is going to own a copyright in the lyrics. Now, if 5 people or 6 people contribute to the sound recording, then those 6 people also have a copyright in the sound recording. And so it can become complicated sometimes. But I'm talking about in the future when you want to assign the copyright to a publisher or to a record company, that's when it becomes complicated. But when you're just talking about registering it, you just have to make sure that you're including the right owners in that copyright registration. And that part is pretty straightforward. Okay.
Now, if somebody changes a lyric or something in the song, is it necessary to file a whole new copyright application?
That is a really good question.
I've done it. I've actually changed words in some of my songs and filed another because I didn't know what to do.
Yeah, that is a really good question, actually. And
it's tricky.
My gut tells me that if you've changed the work substantially, then it becomes a whole nother copyrighted work.
Okay.
If you're only changing a lyric, I'm not sure that it would be changed substantially enough to where you would now own your own entire song, or you would be the owner of an entire new set of lyrics. Because then I would say, well, one lyric is not, like I said, substantially changing the entire composition of the work.
Understood.
Yeah. And so that is where you get into, blurry lines.
Right. Yeah. I guess it really comes down to if there were an infringement and it did go to court, it would be up to a judge or a jury to decide that.
Well, either. It could be either.
Yeah. Which is really unlikely unless you hit it big with something and somebody just blatantly rips you off big time, which is pretty rare, I have to imagine.
Yeah. I mean, it doesn't, I'll be honest with you. Sometimes it doesn't matter how big you are, although that certainly is one of the factors. What matters more is how deep are your pockets. And so sometimes small people can have deep pockets, or very popular people obviously have big pockets.
Right.
And so I think that that's really what it comes down to. Or even if the defendant has big pockets, then it might be a worthwhile case for the plaintiff.
Right.
So I think that those are the factors to analyze.
Do you think that you remember ever hearing about the poor man's copyright, where you fold up your lyrics, put it in an envelope, and mail it to yourself? Is that useless? It's kind of stupid.
I've been asked about that before, and it's
like, how do you prove it, right?
Like, it's not in like the lawyer's handbook. It's not, copyright lawyers don't learn that in law school. And so I'm pretty sure that wouldn't be like a default method that I would recommend to a client. No.
I gotcha. So if a band files a trademark and it's approved, and some other band starts running around using the same name, what does the band who owns the trademark do?
The band who owns the trademark, now, if it's registered, they can sue them in federal court.
I mean, do you do that right away, or do you say, hey, cease and desist, stop using my name or I'm going to get you? Like, what do they really have to worry about it? Because a lot of bands just, hey, I like this name. I'm going to call myself Oranges and Apples, and I'm not worried if there's some other guy. I don't have to worry about it. But if somebody... go ahead.
I was about to say, actually, that, but there are a number of steps that you can take before you just decide to file a lawsuit. And yes, what you mentioned is one of those steps. So, on the most basic level, you can say to them, you can reach out personally as a band member. Let's say you want to save on attorney's fees, reach out to them and say, you know what, I've been using this name since, such and such date. You need to stop using this name, or, I can pursue legal action, but I'm not, I don't want to get there. So let's just resolve this amicably.
Cool.
Then it could go either way. They could say, oh, you know what? I had no idea. And many times that is the case. They simply just don't know. And so they'll say, okay, I'll stop. Other times they'll say, okay, but I don't care. And so then that's when you can decide to see a lawyer, and then a lawyer would probably send them a cease and desist letter or reach out to their attorney and kind of try to do the same thing amicably. If that doesn't work, then a cease and desist. If that doesn't work, then you can file a lawsuit.
Gotcha. But you could just file a lawsuit right away.
Yeah, you could. If you.
Wow, that's ugly.
If you feel aggressive that day, you can certainly file a lawsuit. But just make sure that you're going to feel aggressive the next day and the next day and the next day, because it's not the kind of thing you want to play around with.
Right. It starts to get kind of expensive. So is it expensive to file a trademark? A lot of bands have asked me this. And
that's all relative, right? To some people, it's like, wow, that's so expensive. And to other people, it's like, oh, that's a small price to pay for protecting my brand.
Right.
But the application fee at the USPTO can be $225 or it can be $275 depending on what kind of application you file. And then of course, attorney fees can range anywhere between like $600 all the way to $1,200. It just depends.
Okay. It depends what kind of walls you're running into, how many classes, whether you want to file the logo and the name.
That's right. So you're going to be looking at $225 or $275 per identification of goods and services.
Okay.
So that means that, let's say you just sell hoodies, clothes, then that's one class. But now if you're going to sell hoodies and CDs, you have or downloadable music, and then you're also going to sell, I don't know, what's an example? Just car parts or something, because that's your hobby. Under that same brand, then you're looking at 3 different classes, so it would be $275 times 3.
Oh,
yeah.
Okay.
And then your attorney fees if you are filing through an attorney. So yeah, there are costs to look at. A lot of people just use one class, the one that they mostly are using and want the most protection in first. And that's really how you have to look at it if you're looking at budgeting for this thing.
Right.
But if you want to be comprehensive, you should select all of the identification of goods and services that are applicable to you.
Understood. Now, what if I'm a band and I like Mercedes-Benz and I want to call my band Mercedes-Benz? It has nothing to do with cars, but can I get away with trademarking Mercedes-Benz as the name of my band?
That's a great question. I'm really glad you asked. And so when you're filing an application and you select your identification of goods and services, you are protected in that class only. So if I have an application for or a registered trademark for Mercedes-Benz in automobiles, then chances are that somebody who wants to register Mercedes-Benz in chocolate or in soap or in something else might be able to use Mercedes-Benz in those other classes. And it's the reason why the brand name Dove exists in chocolate and also soap. Okay, so, but I have seen that with big brands like that, what they will do is, even if you're in something completely unrelated to automobiles, Mercedes-Benz still might send you a notice saying, hey, we're going to cancel your mark if you don't cancel your application. Or we're going to file an opposition to your trademark application if you don't stop or if you don't abandon it. So sometimes they can get territorial and, brands, sometimes, not all of them, but they do tend to take on bully-like characteristics just because they don't want anybody on their playing field at all.
I can understand.
Whether it's in that category or not.
They probably don't want somebody to tarnish the brand using the same name.
Right.
Yeah. I actually got zapped. I filed a trademark several years ago for a computer company. I used a Red Cross. Mm-hmm. Like the American Red Cross came after me, heavy cease and desist, filed an opposition. Okay, I'm done. It scared me.
What was the category that you registered in?
Computer repair.
Oh, computer repair.
Yeah, it had nothing to do with medical services or charitables it was just, they just wanted to protect that Red Cross. They said, you can't use that Red Cross for anything else. I see a lot of people.
Yeah, that's a perfect example of what I was just talking about. Yeah. I mean, brands that
it was bullyish. It seemed bullyish. It was the perfect. That perfect.
Yeah. And so sometimes that can be worked around if one little tip or trick is if you know how to use the T-tab, then you can look at the history of how they've dealt with other oppositions. Oh. And that'll kind of give you an inkling as to, okay, this is how they're most likely going to treat me, but we still have to play the game and go about, going back and forth. And so that part still costs money. Yeah. But at least it'll give you an idea of whether it's worth it to spend that money through an attorney or, spend the time if you're doing it yourself. You can gauge whether it's worth your time or money by looking at how other oppositions have played out.
I'm going to tell you right now, everybody who's listening, you need to do any trademark through an attorney because, again, I've tried it myself and I've ended up in flames a couple of times now. It looks easy up front, but it's really, especially if you're serious about your business.
Yeah. If you're serious about your business and you've invested a lot of time thinking about the name, there are people who, say, I haven't even started using the brand name yet because I put so much thought into what I was going to call my business, only to find out a couple of months later that they're not even able to use it because there's a likelihood of confusion with someone else's mark.
Right.
And then they don't know how to get past that. And so if you've invested a lot of time and you want to make sure that it's going to get done properly, then yes, I would suggest that you hire an attorney.
What's the weirdest thing you've ever seen in your career so far in intellectual property? Weirdest kind of infringement or situation that you can share? Obviously, you can't tell us about everything. Maybe generically?
Well, what I would say is that lately there have been some Chinese laws that have incentivized Chinese sellers to register their trademarks in the United States. Mm-hmm. And so, the names that they tend to register typically are not words that make sense or that you're going to find in the English dictionary. It's usually a combination of letters that just, whatever, that you can't even pronounce. Yeah. And so on the one hand, it's good because that is usually my recommendation, choose something that may not even make any sense to anyone.
No confusion.
To increase your chances, right?
Yeah.
But yeah, there's a whole lot of those coming from the Chinese market, which is fine, but yeah, I think that's been the most surprising thing lately.
Wow, that's weird. But not unexpected. Not unexpected for sure. Well, thank you. Marcella Dominguez, how do people find you if they want to use your services for, you do copyrights and trademarks primarily.
Yeah.
You also set up businesses. You advise people,
I do. Uh-huh.
like a band. Should they be an LLC or a corporation? Really depends on their situation.
Yeah, that definitely depends on your situation. I mean, you want to talk to an accountant about which structure is more advantageous for your situation.
Okay.
But then once they help you decide which is most advantageous, then yes, we can help you move forward with that entity.
Awesome. So how do people find you? People need you.
So I'm Arts Music Lawyer on every social media platform, or if you just do a Google search for Marcella Dominguez, you will most likely come across my website or my YouTube channel or some information I'm putting out there.
So you do a podcast, which I've seen, and you have a YouTube channel which talks about IP?
Yes. So I have a YouTube channel, and it's really easy. YouTube.com/trademark lawyer, all as one word, no spaces.
Awesome.
Or if you just do a search on YouTube for Trademark Lawyer, chances are you will find me. And my podcast is on iTunes, Stitcher, SoundCloud, and also YouTube. And it is called The AM Show with Marcella Dominguez.
Awesome. What does AM stand for?
It stands for Ambition and Motivation.
Nice. I like it. Well, thank you so much for sharing your experiences and some of your knowledge with we have a large indie audience ourselves, indie movie makers, indie authors. And would you come on again? Can we talk again soon?
Yeah, absolutely. Anytime.
Awesome. We've got millions of questions, and I'm sure you've got a lot of great situations and experience to share. And look this young lady up, ladies and gentlemen. She can help you get to the right place. And man, I'm telling you, don't mess with that trademark stuff yourself. Just take my word for it. Been there, done that. Won't do it again. Thanks again for coming on. Let's talk soon.
Thank you for having me on.